Lordship, I beg for listing of one bail application.
Yes, yes.
Ma'am, for listing of one bail application.
When?
Ma'am, kindly list it on 28th, on Monday.
Okay. Have you applied for bail in the lower court?
Yes, ma'am.
Sessions tribal case?
Yes, ma'am.
Okay. All right. Yes, yes.
Ma'am, is it?
May it please your lordship. Lordship, I beg to mention item number 24, lordship. Should the matter be passed over for the day, lordship?
Item
number 24.
24.
Counsel for the petitioner.
And a CD available, man.
We'll send it back then.
Fine.
Lordship.
Learned counsel for the petitioner has prayed for adjournment. Please the matter on. Are you on interim bail?
Lordship, 8 May, lordship.
CD is received, send back the CD. Call for the uploaded CD. Interim order, yes, yes.
Lordship.
Interim order shall remain in force till then.
8 May, lordship. Oblige your lordship.
May I please your lordship? I beg to mention item number 43, my lord. Can this matter be taken after a week, my lord? Any date, my lord?
CD is available, man.
Petitioner Mr. D. Bora has prayed for adjournment. You retain the CD for
Right.
1 week.
Return the CD.
Retain.
Retained.
CD is received. Please the matter on F of the video. CD to be retained till 1st of May.
First of May, madam.
Please the matter.
There's an interim order, madam.
Interim order shall remain in force till then.
We do have this.
May I please, Lordship? Lordship, I beg to mention item number 15. Update case diary not received.
Updated case diary as called for is not received. Issue reminder, list the matter on.
Interim is there, man.
Interim order shall remain in force till then.
13 May.
May I please your lordship? I beg to mention item number 37 of daily list, lordship. Lordship, due to some personal inconvenience, we won't be able to do the matter today. I humbly pray that this matter may be adjourned for the day.
Item number 37. CD also not received.
Learned counsel for the petitioner has prayed for adjournment. List the matter on. Issue reminder to forward the CD on.
Lordship, I am on interim, lordship.
Interim.
Interim.
37 হইলে নব নব দেখা
You are on interim.
Yes, lordship.
Interim order shall remain in force till then.
the CD not received. 14.
I am obliged, lordship.
May it please, Lordship. Lordship, item number 35, Lordship, may be taken up along with item number 29, Lordship, arising out of same FIR, same CD. 35 along with
35 and 29. We'll
29.
take it up together.
Fine.
obliged, Lordship.
We'll call 35 also.
Fine.
When we reach 25, we'll call 35 also.
29, Lordship. Obliged.
May I please, Lordship? So I beg to mention item 9 from daily list matter. This matter may come up any other day.
Learned
Item
counsel
number
for the
9.
petitioner, Mr. A. Ahmed has prayed for adjournment. List the matter on.
Any other date matter.
Item 1.
May it please, your Lordship. Lordship, this is a regular bail application, Lordship. 4 persons are behind the bar, Lordship.
Charge
Yes, Lordship.
Charge
Charge case. Lordship, the
What are the
petitioner number 1 is 114 days. Lordship, in this case, Lordship, the section 47 and 48 has not been followed. That is the ground I have taken here, Lordship. Lordship, that Lordship, ground of reason of arrest, that is not given, Lordship. Arrest memo, may I take, Lordship, the first FIR, that, Lordship?
No, let the person reply because this is not at the investigation stage.
Charge sheet, I have annexed that, Lordship. Arrest memo kindly come to the page, Lordship, 33, Lordship.
Yes, arrest memo, yes.
No ground of arrest, no reason of arrest.
47 and 48.
Minor.
Not complied with.
Annexed.
Yes, Lordship.
Where?
That is the Lordship arrest memo and Lordship this
No,
can
48 is not arrest memo.
47 Lordship, page 33, Lordship. 33, page 33, Lordship.
It will be noticed to information to relatives. 48.
Minor.
48, that was not given, Lordship.
Have you annexed?
Lordship kindly come to
Not the next.
information 47, that is on page 65, Lordship. And co-accused lordship already granted by the court below on that ground lordship 47, that is, may I please that
My
order?
lord, here, Lord, may kindly page 66, my lord.
Hmm.
Page 66, my lord, Nizamuddin, he is also petitioner, my lord. Last portion, my lord, reason of arrest, my lord.
Reason, but ground of arrest is not given.
No, no. Your argument is not relevant here. Reason can be mentioned as grounds also.
But
Grounds can be
communication,
mentioned as reasons also.
but there is a specific reason is for just formalities to oppose lordship. That's why lordship.
No, my lord, that
no,
lordship
no.
may call for only
Well, let us call for a track.
record, my lord.
See,
What
this
is there in the record, my lord?
We'll see, check 48. If 48 nothing is there,
My lord,
then I'll grant you bail.
The short date lordship then.
Yes.
record will come, my lord.
Call for the scan copies of the trial court records along with the scan copies of the CD. This is the matter of.
Lordship, it will be too long, lordship. Can it be?
Second May late. Today is
Today is
25th.
25.
Lordship, in this case.
3 days are holidays from today.
Okay, lordship. I'll leave it.
May I please, lordship, pass over for the timing, lordship.
Here, lordship, that grounds of arrest not communicated to the arrested person, lordship.
Mm.
That lordship passed the earlier order at page 35, lordship. But at that point of time, I could not place before that Prabhu Purkasta judgment. Therefore, that which says, lordship, it is mandatory to give it in writing, lordship. Therefore, your lordship passed an order.
Where is the Prokasta judgment?
Lordship, just I'm placing. Prabhu Purkasta.
Paragraph. Page. Okay, I
Uh,
got it.
Yes,
Page
Prabhu
21, para.
page, para 48, lordship.
Please read the paragraph.
Lordship. And before that, lordship, may I kindly say paragraph 37, lordship.
Paragraph
yes.
37. Yes, yes.
37 that in that lordship, in that case, how that was written in the arrest memo, what was written in that arrest memo and what is written in my case, that will clarify. Lord. Paragraph 37. May I read?
Yes.
The interpretation given by the learned single judge that the grounds of arrest were conveyed to the accused in writing while the arrest memo is unacceptable on the face of the record because the arrest memo does not indicate the grounds of arrest being incorporated in the said document. Column number 9 of the arrest memo, annexure EP7, which is being reproduced herein below, simply sets out the reasons for arrest, which are formal in nature and can be generally attributed to any person arrested on accusation of an offense, whereas the grounds of arrest would be personal in nature and specific to the person arrested. Reasons for arrest: prevent the accused person for committing any further offense. B, for proper investigation of the offense. C, to prevent the accused person from causing the evidence of the offense to disappear or tampering with such evidence in any manner. D, that to prevent such person from making any inducement, threat, or promise to any person.
Just one moment, see. When we have it awkward, yes, awkward. Yeah.
Lordship, they will approach the court below, lordship.
Okay.
Am I allowed to?
To item number 1, learned counsel Mr. B has paid for withdrawal of the application. Heard Mr. B. Sharma, learned action PP Assam. Petition is dismissed on withdrawal.
Obliged.
What is the item number 3? Your lordship has fixed on 7. Can it be on 6, lordship? I have.
Yes, can be, can be.
Obliged.
May I please, your lordship? My lord, here the petitioners were arrested on 20th of March, my lord. Today is 36 days. And what happened, my lord? On 21st of April, we have filed this bail application, my lord. The next day, the charge sheet is submitted. We got the information started. Started, my lord, some co-accused bail petition was fixed before this honorable
Yes,
court.
you have stated no, yes.
Yes, my lord.
I know.
So my humble submission, my lord, since anticipatory bail was considered for some persons, my lord, there since 36 days in jail, my lord.
Mm.
We consider, my lord, because it was the incident, my lord, regarding, my lord, the rash and negligence motorcycle driving by the son of the present informant, my lord. And all are the villagers, my lord. Initially, it was tried to settle, my lord. And somehow there
You
was a, my
will
lord,
approach the trial court, you approach the trial court.
I will
Charges
approach, my lord, the
submitted.
direction may be given so that the court can consider, my lord. And anticipatory is from the similar situation, it is allowed, my lord. They are in jail since 36 days. So bail may be granted in this case, my lord. Since a sheet is submitted, they will appear, my lord, as and when
Will
required,
you-
under
I
any
don't
terms
give
condition.
Any observation? Charges is submitted, you approach. Why should I give any observation? If I give any observation, it will be to your disadvantage. You approach, no problem as such. Charges is submitted, you approach, otherwise I will call for the CD. So what is the benefit? Where is the benefit?
Well, the shall consider may be mentioned, my lord. Otherwise,
Why?
the court,
I'm saying it will be to your disadvantage if I
Yes.
write all this.
yes, your lordship.
Our learned counsel, Mr. N. Uddin, for the petitioners. And learned additional PP, Mr. B. Sharma, for the respondents. It is submitted that Shashit has been laid
Minor.
against the petitioners being CS number.
3/25. 3/25 dated 22/4.
And the petitioner is at liberty to approach the jurisdictional court and apply for bail, which may be considered by the court in accordance with law.
I'm obliged.
Wait, please, your lordship. Okay, the petitioner is behind the bar for 51 days, your lordship. And co-accused who was arrested, in this case, he has already been granted bail, your lordship. FIR lordship will get at page number 8. Lordship has in fact produced the CD also, I think, because the page 8 is the FIR. Lordship. May I read, your lordship?
Mm.
To the officer in charge, so and so, dear sir, this is to inform you that on 18th February at about 5:30 p.m., two unidentified males on a two-wheeler attacked Mrs. Hiranmai Bhattakur, a female of 68 years.
Oh, this one, yes.
There's a minor dangerous.
I think I have gone to the CD
CD
also,
marriage.
because he applied for anticipatory bail, I think,
No, regular bail, I think.
earlier.
Earlier,
Then-
not this person,
Ah.
co-accused, two persons were arrested on the same time, your lordship. The co-accused approached and this honorable court was pleased to, after refusal of CD,
Mm.
place him on bail, your lordship.
Yes.
On the-
Triple kindly see para 6.
Hmm.
There is an observation by your ladyship that there are incriminating materials in the case diary against the petitioner in that case. Your ladyship will remember, this is that case where there was a bike rider.
I know. I remember it vividly.
This is the person who came from behind and
Ah.
hit the lady and pushed her to the ground.
There are photographs also.
Yes, there are photographs. And ladyship, if his ground is parity, ladyship is very well aware of Ramesh Bhavan Rathore. Parity he'll have to prove by showing that in the case diary, in the investigation, the IO has seen that the roles are similar, or if the IO has seen that the roles are different, then parity will not apply.
Roles are similar.
No, your ladyship, they're different because in this order, the person who was there, he was on the bike, he was waiting. He had no involvement in assaulting the lady physically. So the roles are different in that respect, number one.
34
Number two.
slash 34,
Number
61,
two,
61 or 64, Janu? I don't think so. Let him go on bail.
No, number two, your ladyship, they've suppressed their antecedents. Your ladyship will kindly see, we have taken out fire where they have been arrested. And they've suppressed this. Your ladyship, there's a recent judgment by the Honorable Supreme Court, where the Supreme Court has said that if there is a suppression of antecedents, then there cannot be grant of bail. Your ladyship will see, this is the FIR. The last 2 pages, your ladyship, they are the forwarding report. Your ladyship will see this person, Asadul Islam, son of Kudus Ali, address Matibata Gaon, PS Fokirganj. This is the person who has been forwarded. This is the petitioner, your lady.
In connection with
That's a different case, your lady.
under which section?
379 and 356 and 379. That's on the first page.
Oh,
Now your ladyship will see there's a recent
he's
order.
a history sheeter.
Yes, he's a history sheeter. There's a recent order, your ladyship. This is an order of 3rd of April 2025 by the Honorable Supreme Court in Munnesh versus State of Uttar Pradesh. Your ladyship will please see for a moment para 9.
In serious offences, definitely antecedent will count.
No, in
Not
any case,
in
your
petty offences.
In any case, and in this case, your ladyship, in this case also, your leadership will kindly see the nature of the injuries.
This is 379, 411.
Yes.
Hmm.
Your leadership, para 9 in the Supreme Court order is very clear. Be that as it may, since the petitioner has suppressed material facts with regard to his involvement in criminal cases, he is not entitled to the discretionary relief of bail. Para 9 at page 2. And ultimately, your leadership will also see, it has been the consistent stand of the Honorable Supreme Court in this case also.
No,
The-
see, you see, this case is under section 302.
No, leadership, the facts are different. The offense is also different, and I'm not on that.
Mm.
With all due respect to leadership, what my humble submission is
How many days you are behind bars?
50 days.
54 days.
Another
51
10
days,
days
51.
should be eligible for this bail.
Yes, for
Uh,
default, yes. I'm not on that.
statutory-
For default bail, if charge sheet is not filed at that point of time, he will be entitled to it. I'm not on that. What I'm on your leadership, there are two things. Number one, your leadership, his role and the role of Safikul, in this case, in my
No,
humble
I'm
submission.
granting bail.
Number two,
sorry.
your leadership will please see for a moment. They have suppressed their antecedents.
Yes, they have suppressed.
They have
So,
suppressed. Your leadership.
no
of
doubt
Supreme
he's
Court-
behind bars.
Huh?
No doubt he's behind
No,
bars.
leadership, the fact here is your leadership.
No,
that
no,
when
no,
there is a
no,
suppression
no,
of
no,
material
no.
facts before
No,
your
no.
leadership,
No,
the leadership will
I'm
kindly
granting
note,
bail.
leadership will kindly note that the FIR has been produced before your leadership, the certified copy of the FIR and the forwarding as well. Because leadership, our humble submission is if there are antecedents which are being suppressed, then bail, your leadership, the discretionary relief ought not to be granted. Such thing. That may be recorded.
I'll record it.
Very good.
Our learned counsel, Mr.
MH loss.
M.S. Siloskar for the petitioner. Asadul Islam, who has filed his application under section 483 of the BNWS 2023 with prayer for bail as is behind bars since 5/3/2025 in connection with so-and-so PS case under so-and-so sections are Mr. B. Sharma, learned edition 50 Assam, and learned counsel Mr. N. Gautam, no?
Here you go.
A. Gautam for the informant. It is submitted on behalf of the informant that the petitioner has suppressed criminal antecedent. The petitioner is a history seeker and he has been involved in an offense under section 356/379 IPC, which is registered as Dispur PS case number 553 of 2023. Full stop. The petitioner has submitted that it is tried law or the learned counsel for the informant. Learned counsel for the informant has submitted that it is tried law that when antecedents are suppressed and when an accused has criminal antecedents, he is not entitled to bail. But Mr. B. Sharma, learned additional PP, who has raised objection against the bail petition of the petitioner.
Without perusal of the case there.
Huh?
Without perusal of the case there.
Without perusal of the case diary, without scrutinizing the case diary. Full stop. The petitioner has prayed for, I have considered the submissions at the bar with circumspection. The petitioner has prayed for bail on the grounds of parity. The petitioner is behind bars for 50 days. 50 days. The co-accused has already been enlarged on bail by this court by the order dated 10/4/2025 in connection with BA number 837 of 2025. It is submitted that the petitioner is willing to abide by any stringent bail conditions if imposed upon him. The petitioner has also pledged to cooperate with the remaining part of the investigation. It appears that bail may be granted to the petitioner. The petitioner is enlarged on bail of rupees 50,000 with a suitable 30,000 with a suitable surety of like amount to the satisfaction of the learned CGM Kamrup Metro under the condition that the petitioner shall appear before the IO on every fortnight till completion of investigation. The petitioner shall not leave the jurisdiction of the court without prior permission. The petitioner shall refrain from such activities with which he is alleged. On breach of any of the bail conditions, the court is at liberty to immediately cancel the bail granted to the petitioner. Item number 5.
Oblige.
May your lordship, it is a regular bail application, my lord. In this matter, lower court record may be called for moment.
Call for the scan copies of the trial court record along with the scan copies of the CD, list the matter on.
If possible on 9th of May, my lord.
File.
Of last month.
Item 6.
My lord, the petitioner behind the bar for about 58 days. And the affair, my lord, is 8, really false case, my lord. So far the affair, the
Report minus.
Hmm?
Report is in minor.
Any case registered?
No.
No criminal cases pending.
Minor.
Seen the reports forwarded by the IO that no criminal cases pending at Panbaza PS
Fine.
against the present petitioner. Matter stands closed.
Bless.
Item 8.
You want back the report?
Minor. That's a as a record. Part of the.
Lordship, this is a second bail application, Lordship. At this stage, Lordship, I am
Ready.
praying for
CD.
CD.
Call for the CD, list the matter on
On 9 May.
9 May.
Item number 10 for bail hearing.
Oh. আজি অহা নাই ন?
None appeared, madam.
Both the others next week I'll dismiss it. যোৱাবাৰ অহা নাছিল নেকি? এটা দুইটা party অহা নাই. Both the parties are absent. Both the parties are absent and not represented. List the matter on. For interest of justice, list the matter on 7 May.
Item 11.
After sometimes, 11.
Hmm?
After sometimes,
After some time.
yes.
Why?
So HOD, he wants to appear in this case, man.
Why you submit?
No, my, yeah, he has the brief with him, my lord. Yeah, so he's coming on the way, my lord. 11 and 14, my lord, will be taken
12,
after
11,
some-
12.
11 and
Whenever you please.
12 to Amar, no. 11 and 14, do taken after some time.
What with?
Brief is with him, my lord, that's why, otherwise I would.
Item 12.
My lord, clear ones are for the time being, my lord, and I seek your permission to go through the trial court record once, my lord. Item number 12. I'm deeply.
May I please, Lordship? In this case, my lord, the petitioner is behind the bar for 69 days, my lord. The Lordship will kindly see the forwarding report, my lord. In the forwarding report, my lord, the other
You
two
have
main
the
equals towards arrested, my lord. Seriously, sir.
CD you have?
Yes, that is similar.
Where is the, okay. Where is the FIR?
My lord. It is, my lord, 7, my lord.
Page 7.
Yes, my lord.
Tanya Begum.
Yes, my lord. She is the wife of the deceased, my lord.
Yes.
My lord,
Well-
we have received proposal.
My lord, my humble submission is that.
No,
my-
no, no.
Oh, yes, ma'am. Yes.
We'll go through the
yes.
records. It's a murder case.
Yes, ma'am.
My lord, this, my lord, lady, my lord, Sania Begum, my lord. She is the wife of the deceased, my lord. And she is having, my lord, extramarital. My bill, sir. Perfect. The case is fixed for CD today.
You have the CD?
CD, case are not with the body.
Okay. Serious call for is not received, we should reminder, list the matter on. Interim order shall remain in force till then.
14. Be published.
Oh.
17 also case there is no.
CDS call for is not received, we should reminder, list the matter on short date, no? You are not on interim bail.
One
Okay.
person is on interim bail, that is petitioner number 12, Lordship.
Okay. The interim order of petitioner number 12 shall continue till then.
Hello.
17 to get a.
My lord, in this case, already matter has been settled up on compromise, lordship.
Oh.
On last occasion, last occasion, learned PP informed the code also,
Okay.
lordship.
Okay. Third learned counsel, Ms. S.K. Nargis for the petitioners. Injan ase, huh?
The injury report not received, my lord, in this case. We have received the case diary, my lord.
My lord, last occasion, this submission made by the learned PP lords, it is reflected in the CD also. Why name?
Ketia.
Settle হৈছে সিহঁতৰ মাজত কেছটো সিহঁতৰো এটা ক্ৰছ কেছ আছে সেইকাৰণে settle হৈছে
No, last occasion I have not appeared, my lord. If somebody else appeared.
as Bora was there lordship, that is why lordship.
Their statements are in the CD. Earlier we have sent back because the statements were not there in the CD.
My lord.
But learned PP stated that it was settled because cross case was there.
Not noted, not recorded actually. Maybe VP has stated, maybe.
No, my lord, it is not there, my lord. Because my lord, CD is up to date up to my lord 15th of February, my lord.
We'll continue with
Yes,
test the
absolutely.
interim order. The learned additional PP, Mr. R.J. Bora has submitted that. CD is not up to date, sent back the CD, call for the up to date CD, list the matter on. Interim order shall remain in force till then.
They should send back the CD lordship.
Yes, we'll send it.
Okay, দিব
Send back the CD লিখি দিয়া।
এইখানে আহা নাই।
6 এটা করে দিন।
Call for the up to date CD.
Interim shall continue.
Yes, it will continue.
Obliged lordship.
CD হবে। My lord, I am on interim. That is not received, my lord.
CDS call for is not received, we should reminder, list the matter on. Interim order shall remain in force till then.
May please your lordship here, a young boy is involved on lordship, although he was not participating in the last occasion, twice lordship case that he was called lordship.
You have the CD.
Yes, that is not received, my lord.
This time also, may I pray lordship to facilitate the investigation? I may be allowed to.
What is the offense?
Offense is lordship, what has happened, the fact I'm briefing, the petitioner, he has a rented car. So he was standing and in front of him, some altercation took place between and there was marpit. Thereafter, this petitioner, one of the accused, accompanied him to go to police station. So he took him to police station with his rented vehicle. There he saw the other, the victim person. So a case, in that case, he has also been implicated. So that is the lordship. Otherwise, also for social reform lordship, let him get a chance lordship, let him appear. Let him appear lordship. Because sending in jail is full of all heinous crimes lordship. It's not something intentional. So I have detailed in my all statement what has happened actually.
We'll leave the CD. We'll leave the CD, sorry. CDS call for is not received, we should remind a
Then
very short
post it
date.
for a short date,
Yeah, short
lordship.
date. 2nd May. Before that, it won't come.
I'm deeply apprehensive.
Issue reminder लिख दिया. For the CD along with the injury report of the
Lordship, this
victim.
time positively, lordship. This time positively.
For the CD positively along with the injury report of the victim.
Or else my petition will be considered.
No.
May I please your lordship. Lordship, 21.
Your Lordship, the matter is pending since 3rd of March, Your Lordship, and today it is the 4th time, Your Lordship. If Your Lordship would peruse the FIR for a single time, Your Lordship. Once, Your Lordship.
I has paid for some time, my lord, because due to my lord, law and order duty, my lord, he cannot forward the case diary.
Your Lordship, 117 and 118 of 2, Your Lordship. In the night of Uruka, Your Lordship, on 13th of January, Your Lordship, that incident happened, Your Lordship. Earlier, what has happened, Your Lordship? The son of the informant, Your Lordship, on Uruka, Your Lordship, when everyone, no one was there at the house of the petitioner, Your Lordship, he went to the house of the petitioner number 2, Your Lordship, and tried to snatch the mobile phone of wife of the petitioner number 2. Thereafter, some hue and cry occurred, Your Lordship, and in the night of Uruka, that incident happened, Your Lordship. We have also approached before the, Your Lordship, CJM Nolbari, Your Lordship, and an FIR has been registered against them also, Your Lordship. Till CD comes, Your Lordship, he's appending police arrest, he can be protected, Your Lordship.
Allegations made in the FIR are very serious.
Both the parties have,
No.
both the parties have been injured.
Serious call for is not received, call for the CD positively on,
Seven.
along with the injury report of the victim.
Uh,
28 also may be taken up, same case.
28, all right. 28.
Lordship, here, Lordship, there are 3 petitioners in 22, Lordship. Petitioner number 1 is the son, and the 2 and 3 are the parents, Lordship. Lordship will come to the FIR, Lordship. I'm already protected by
You
this.
have the CD?
Case diary is similar.
I was already
I'll
protected.
take up which one first?
22, Lordship.
22.
So,
I'm putting it.
Okay.
Lordship, I was protected and I appeared before all the petitioners, they appeared before the IO, Lordship, as per the instruction provided to me, Lordship. Lordship will come to page, Lordship. 15, Lordship.
Page 15.
15, that is the FIR, Lordship.
That's what it is. That's what it is.
FIR. Lordship, this is stated in the details of the incident, Lordship. On 1st March 2025, approximately 4 p.m., while I was standing in front of my residence, the aforementioned individual attacked me without any provocation. They assaulted me with a heavy iron rod. Lordship will just take note of that heavy iron rod, Lordship, striking me on the head and causing severe injuries, severe and dangerous injuries. The entire incident has been captured on my CCTV camera as evidence. I am deeply distressed by the unprovoked act of violence and fear for my safety. I therefore request you. So he has prayed for registering a case and he has prayed for legal action. Now, Lordship, they have come with an objection, Lordship. What they have stated in the objection, they state that he was attacked with a bamboo. So his statement is already contradictory. Lordship, these 2 petitioners, the petitioner's residence and the informant, they are adjacent, Lordship, neighbors. And on that day of incident, Lordship.
It's okay. What do you have in the CD? What is the
Yes, my lord.
injury?
Case diary received, my lord.
Hmm.
My lord, as per the case diary, my lord, the person, my lord, petitioner in item number 28, Dulal Deka, my lord, he assaulted the, my lord, victim, my lord. He assaulted the victim along with a bamboo stick, my lord. And the bamboo stick was brought by Nibaran Bora. That is, my lord, petitioner in item number 22, my lord. Petitioner number 1, my lord. He brought the bamboo stick, but my lord, Dulal Deka, he took the bamboo stick and assaulted the victim.
Victim is Hitasodeka.
Hitasodeka, my lord.
Yeah, he
And
has
my lord,
sustained injuries.
injury report we have received, my lord, along with the case diary, my lord. It is reflected that, my lord, simple, my lord, caused by blunt weapon.
Then it is bailable.
Yes, bailable.
Is it maintainable? Bailable?
That
But
118 will not
question
come.
is that, my lord, he has
118 will not.
109?
my lord,
10.
assaulted on his head, my lord. That is the important aspect of the matter, my lord.
He could buy it.
No,
Section
Lordship.
109.
Entire incident is recorded.
Then I have seen a murder case with bamboo lathi on his head.
That they can
A
tie,
person
Lordship.
died and then
But
I was.
Here the
I
injury is simple, Lordship.
passed the judgment also.
And the very next day he lost the affair also, Lordship. Nothing serious, Lordship. And they have already appeared. They will cooperate with the investigation, Lordship.
Very aggressive. Nibaran Bora and
Nibaran Bora, he brought the bamboo stick, my lord. And from Nibaran Bora, my lord, Dulal Deka took the bamboo stick and assaulted the victim, my lord.
Dulal Dega is the driver of the Nibaran Bora.
Custodial interrogation may not be necessary, Lordship.
They have APR statement recorded, my lord. Yes.
I'll just see the statement.
It
of
will
the
definitely-
victim.
Victim will implicate us, Lordship, because he has,
No, victim
even
is
his
there, there are-
objection, he states that he is
the eyewitness
making
also
some
there.
in.
He tested us.
Yes, he is in his objection, he has stated that he
Handwriting
is
is
making
very
some.
poor, my lord. It will be-
Oh no. Horrible handwriting.
Yes, ma'am.
Never mind. Let me see. I'll just read the
Don't be
statement.
paid
of
out,
the
my lord.
victim.
It will be difficult.
Only the statement of the victim.
And
Victim,
Lordship
my
may
lord,
also
previous
peruse
one,
his.
my lord.
I won't read everything
Previous
because it's a horrible handwriting.
Twenty-four to detect is good. उनको दिखाना है आपको. Don't disturb.
There was another case. There was another case.
My lord.
Then that case was registered. And for that case, they have fought.
Yes. An allegation is that, my lord, he works in some, my lord, he do some contract work, my lord. And this petitioner, my lord, the victim, my lord, he used to, my lord, file RTI, my lord, to know about the, my lord, progress of the work, my lord. These are some sort of allegations.
He found some irregularities. He's found some irregularities.
That is another aspect of the matter, Lordship.
And in the year 2023 and 24, he made a complaint to the.
Yes, another case. Another case.
Since then, they are.
They are
No,
neighbors.
not after him. He is also after this petitioner. Both parties, they are adjacent houses, Lordship. They continuously, he keeps
They have
fighting,
any problem
Lordship.
with me. They can go with lawful means.
Lordship will just consider, Lordship, because they have appeared and they will cooperate with investigation, Lordship. And if charge sheet get done, then Lordship, they will face the trial, Lordship.
I'll just see the injury report.
Yes, Lordship.
They say injury could have been grievous also. But they have mentioned it as simple, but we'll have to accept it as simple. On the head. Size is not the ordinary size. 5 into 1 into 1. Centimeter cube. not very ordinary size. It's a prominent injury on the head. Maybe there is no fracture. That is why they have not. Fortunately.
Lordship may consider it be giving some stringent condition, Lordship.
Maybe can be given, I think, huh?
No, that Lordship will be, because they can file a petition, Lordship, for rejection of the bail, Lordship. That condition may be given, Lordship.
No, petition is not required to be filed. Automatically it will.
Yes, yes, Lordship. If he is if any incident occurs of similar incident, Lordship, he may lodge an FIR and automatically that.
Where are their statements? I cannot find their statements. Have they appeared?
They have appeared, but statement is there. Last portion of the CD.
All right then.
With some strict condition,
Under objection, huh?
with some strict condition.
The injury is not very, this is 109 has been correctly incorporated. Heard learned counsel Mr. M. Ahmed.
Yes.
For the petitioners, 1, 2, 3, who have filed this application under section 482 of the BNWS 2023 with prayer for pre-arrest bill as they are apprehending arrest in connection with Central PS case. First of heard learned counsel, heard learned additional PP Mr. R.J. Borwa for the respondent state and learned counsel Mr. N.P. Duara for the informant. The allegation against the petitioners is that the petitioner number 1 brought a bamboo lathi and the other accused Dulal Bora, no?
Yes, Dulal
FIR.
Deka, Lordship.
Assaulted the victim Itesor Deka, no?
Itesor Deka.
Itesor Deka, causing grave injuries on his head. The learned counsel for the informant has submitted that the petitioners are of aggressive nature and nothing can deter them from committing such an offense again. I have scrutinized the case diary and I have considered the submissions at the bar. The petitioners were granted anticipatory bail by a coordinate bench of this court, while order dated 12/3/2025. The petitioners have appeared before the IO and the statements have been recorded. I have also scrutinized the medico-legal report and the victim has sustained simple injuries on his head. Petitioners are willing to abide by any stringent bail conditions if imposed upon them. Considering all aspects, the interim order dated 12/3/2025 is hereby made absolute under the condition that the petitioner shall appear before the IO on every fortnight till completion of investigation. The petitioner shall refrain from such activities with which they are alleged, and the petitioner shall not leave the jurisdiction of the court without prior permission. On breach of any of the bail conditions, bail order shall stand automatically cancelled. Send back the CD. Etu eke likhi diba, khali yate Dulal Bora ase, ha? 28. The story to all of change হৈ যাব. Nivaran Bora লাঠিটো আনিছিলে, Dulal Bora মাৰিলে.
I am obliged.
May it please, Lord. My Lord, CD was called for.
Yes, that is it, my lord.
My Lord. Now, your Lordship will turn to page 8.
Page 8.
8 is the FIR.
Yes, yes.
DCG also. This is a case where Lordship, the loans were being taken with fake documents and guarantors were made, Lordship, without their knowledge, Lordship.
What loan? Loan taken
loan.
with fair, okay.
And various agents.
Housing loans.
Housing
LIC,
loans.
from LIC.
And
Oh,
various,
that's Norway case.
Non-bari case,
Huh?
Lordship.
Non-bari.
Non-bari.
Okay, okay. Some people have committed suicide.
Lordship, that
Okay,
case,
that case.
that case, Lordship. Here in regard to this person,
Hmm.
26, that is Jogen Kolita. His statement is there. And in
Yes,
his-
earlier his statement was recorded. That I have stated, they wanted to know whether it was in the record or not.
His statement is there, Lordship.
Already he appeared before the police. His statement was recorded. And apprehending that he might be arrested. So I am before your lordship.
According to
Any role attributed to him?
according to his statement, Lordship,
Hmm.
he one Soilan Sharma.
Hmm.
He is the main person, Lordship.
Yes,
He is Soilan Sharma. He has taken loan with the help of this person, Soilan Sharma, on 2012. And after his father's death, on 2014, it has been closed, Lordship. But he has given customers to this persons, Soilan Sharma. Again, here section 3(5) is there. So common intention is there, Lordship. It is a level again in the whole case, Lordship. Moreover, it is only that, Lordship. And moreover, in regard to, it is not coming, 34 is also similar, Lordship. Again, regarding this person, only this thing is there.
He himself has taken loan.
His father
His
on
others
2012,
took loan through him.
and he
the main
used to
account.
give
Julian Kolta has taken loan.
Jogen
No.
Kolita's father has taken loan on 2012, and he, after his father's death, 2014, he have closed it. But I have no idea whether that loan is, Lordship, genuine one or not. It is not there,
No, it
Lordship.
was his loan.
Okay. But however, he used to give customers to this person, Soilen Sharma. He is the main accused, Lordship. He used to deal under him. Many people are working, Lordship.
That I have stated in the petition also, that I used to work for some time. Then
Lordship, may look into the city.
and presently he is now having a cloth shop at Nolbari town as his earnings, Lord, and he is not engaged in this loan business.
I'll come back after 5 minutes. I'll pass an order.
My lord.
I'll go through the CD. I'll pass an order
My
later.
lord.
Yeah, you may not. You are not required to stay.
My lord, with due humility, I'd like to submit before your lordships that I'm instructed not to proceed with the case.
Okay.
It is the wisdom of the parties. So I therefore pray before your lordships to withdraw the case.
Council, Mr. Dr. T. Kolita and Mr. B.K. Chanda has paid for withdrawal of this petition. Our learned Mr. B. Sharma. Petition is dismissed on withdrawal.
Item number 29 and item number 35.
In this case, matter so far item 20 is concerned, Kabir Ali. Tell me there already statement recorded. And he is in no way connected, my lord, because after 1.5 years, this case was filed. The notice was, my lord. Your lordship kindly see the FIR is, yes.
29, no?
Oh, sorry, 29.
29.
29 ago? 35 में. Huh?
35.
Or 35. 29 and 35. So your lordship will find my the FIR is page 15.
Page 15.
1-5.
Okay.
1-5. I only, he is not named in the FIR. He got a 41 notice, so the apprehension he came before lordship on page 17. The allegation is that my one truck was carrying, and that ultimately some short of 9,000 liters of petrol, my lord.
I know this.
Oh.
Yes.
So this petitioner only, he got the 41 notice, so this is the apprehension he came.
About this petition, I do not know.
No.
They will know. What do you have in the
It
CD?
is only he is having so many vehicles, he does not have any link with this car, my lord. My petrol pump is otherwise there, my lord. I am having 4 cars, I have given all the numbers, my lord. I have having 4 vehicles, I have given all the numbers of the vehicles. To engage my lord other way. So far the vehicle, my lord, this vehicle is concerned, I have no relation neither with the owner, nor the driver, nor anybody else, my lord.
Okay.
One day I got a notice,
If
41
I look
notice,
into the
and I
FIR
have appeared, I have already my statement to record it.
As per the FIR, Lordship, there are 9868 liters of missing oil is there, Lordship. Out of 5 chambers, 2 chambers were empty, Lordship. And moreover, if you look into the statements of the driver, he has stated that he works under this person, Kabir Ali, Lordship. And secondly, Lordship, he has given the keys to some persons, Lordship, Hiten Das and other persons are also there. And Hiten Das also stated that that they were in a tea estate, they took the vehicle to that place and they unloaded and sell it to other place, Lordship. And in that, the co-accused has named his person, this person, and Abdul Kalam's name is also there, Lordship. And this Abdul Kalam and Sultan, they sold the oil, Lordship, in Dhubri.
Somebody else.
In Dhubri, Lordship. And his person, his name is also there. He helped
My
them.
name is not there.
No, in the co-accused persons have stated
Statement,
them. Statements, their name is there. And Sultan is also stating that he also sold the oil.
Abdul Kalam also sold the oil.
They have taken the, help him to take out the oil, Lordship.
Abdul Kalam.
They are cooperating in an organized manner, Lordship. These persons took out the oil, Lordship. Then these 2 persons, Sultan and one Abdul Kalam, they sold it. And they also stated the same thing, Lordship. Every co-accused, other co-accused who are involved in this case, they have stated the same thing that they were, and they were moreover the habitual offenders also, their Lordship. My Lord, may kindly look into the. I have
And what about Kabir Ali?
Kabir Ali is there.
Name is not there, madam. Co-accused might have stated no, because your lordship knows I have a vehicle, 4 vehicle, my diesel does not match with that diesel, my lord. And somebody stated about me after 1.5 years, my lord. I one day got a notice 41 notice there for I am before lordship, my lord. Nothing is there, no whisper. And nothing is sold to me also, my lord. It is among them, my lord, driver, etc.
Driver have also stated that he was also involved, Lordship.
Your
They were
lordship,
doing the same thing, Lordship. During the transportation, they used to do this type of things, Lordship.
Sonaullah said that
Sonala, yes, Lordship. His statement is also there. I have flagged it.
driver of that
Driver give the keys to this person. He left away, according to the driver. And these other persons have stated that all these persons' names are there, Lordship. Abdul Karim, Kalam, and these persons, Kabir Ali. Clearly named, Lordship. It is not that only one co-accused has stated. They define the role also. Whose person doing what, Lordship.
41, my lord, your lordship, and is the date of occurrence 29/10/23. FIR is page 30/10/23. And 41 notice I received on after 1.5 years, my lord. Nothing, nobody has stated 1.5 years, my lord. Neither in the FIR, nor during this whole period, my lord. Nobody stated my name. Suddenly, my lord, notice after 1.5 years, my lord.
Lordship may go.
Only, my lord, my only question, I have already appeared. I am in extended cooperation, my lord, with this, so as per settling up judgment, my lord. Once if I join investigation, if I am cooperating, of course, my lord. Your
statement has been recorded.
Yes.
Recorded.
Yes, my lord. Everything is there.
Lordship, case is pending for the stolen oil hasn't been recovered yet, Lordship.
So already sold and used.
Yes, that's the somebody has taken it. So my case is, my lord, I am cooperating. I am owner of a reputed businessman. I do not know matter how they have stated, my lord.
But material is there, Lordship, of course.
Anyway, my lord, I have
sufficient
tried
material is
investigation on that ground, your lordship, whatever, I am not on that now, my at this stage, my lord. Since the interim was there, my lord, I appeared as per 41 notice, my statement recorded and cooperating, my lord. And your lordship may put any condition, I'll cooperate, go on cooperate.
I'll pass an order later.
My lord.
I'll go to the city, I'll pass an order.
My lord, I have to submit 35.
What to do?
35, okay. বেলেগ কে দি দিয়া না এটু এই মাত্র 35. 35 to mobile. Yes, yes.
My lord, here at paragraph 5, I have tried to explain, my lord, my.
Yeah, I got it.
My lord, around 2007. My lord, around 2017, I used to be a driver of a tanker. That is the only connection with this, my lord, that tanker and all these things. After that, from 2017, my lord, I have stated on record, my lord, that I have started a business of cloth store, my lord. And I have stated also name of the cloth store as Momi Store, situated at district Sirang. My lord, 2023, this incident has occurred, my lord, as per the FIR. And I have been, my lord, visited, my house has been visited by the police, my lord, around 2025 April. And they have collected my, some documents like PAN card, Aadhaar card, etc. and asked me to come to the police station. That is my apprehension, my lord. Notice also has not been served, just they have come and visited my place. My lord, from 2017 onwards, I have no connection, anything with oil tanker and all these things.
He stated that all the witnesses have stated that you have sold the oil
My lord, who is, I mean,
Which is there in the CD.
in the CD.
I mean, that part, my lord, how it come, I do not know, somebody must have some bigger conspiracy may be there to, but since I have been a driver long back, I may be made a scapegoat because I have no knowledge whatsoever. My lord, at this stage, may I pray, my lord? At this stage,
He's not named, you're not named in the FIR.
not named in the affair, nothing, my lord. 2023,
During investigation, it will come, Lordship.
my lord, after 2 years, my lord. And
Post of the same
yes, now, my lord, I only pray, let me be on the same footing, my lord. Let my statements be recorded, and my lord, I may be given that opportunity to appear, my lord.
Okay, let
I
me
may be
see.
protected, my lord.
Let me see.
My lord,
I'll go to the CD. I'll have to read the CD.
my lord.
And only one citation on industrial also note, my, from that, once I cooperated, I joined investigation. 2011 1 SCC,
Hello, will you hear?
yes,
Everybody.
2001 11 1 SCC 694.
My lord, I am also.
The names of the parties?
Satlingappa.
Huh?
Satlingappa.
Satlingappa.
Huh?
Oh, Satlingappa Metre.
I'm Satlingappa.
Satlingappa Metre.
Yes.
My lord, I am.
AB. I know the judgment.
My lord, I am also.
Secretary Bail.
Yes, yes. Once he joined conversion should not be taken to custody.
My lord, I am also
You are the same.
willing and ready, my lord, to cooperate in the investigation. That is my lord, undertaking, my lord.
Okay,
Yes, yes,
okay.
In my
I have
objection,
noted this judgment in your argument.
yes, my lord.
This judgment I have noted in his argument.
Yes.
Because your record has already gone.
Any matter, same thing in the same.
my objection is there, Lordship, on the ground.
Hello, William, huh?
Essential.
My lord, we are not in
commodity is there,
interim. I am not in interim, my lord.
This
That
is
is
an
a
essential commodity, Lordship.
deeply obliged.
Lordship, kindly this matter may be fixed at 2, Lordship.
CD not available, Lordship.
Then also Lordship fixed at 2, Lordship. The
Strictly
engaged
not-
counsel is coming from another court, Lordship. He instruct me
Okay,
to.
okay, at 2 already.
Oblige, Lordship.
31. 31.
This matter will be infractious, Lordship, because he has been arrested.
Arrested. Petitioner is not represented. The learned medical PP minister. It has submitted that the petitioner has already been arrested. Matter that the matter is closed as it has become infructuous. All right.
Item 33. Item 33.
My lord, kindly pass over the matter for time, my lord. Here we have received the case without the medical report, my lord. It is required, my lord. Injury report, my lord.
We'll call for the injury report.
My lord.
Send back the CD.
My
and
lord.
Up-to-date CD along with the injury
My
report.
lord.
List the matter on. আৰু এটা ফাৰ্ষ্টৰ লাইনটো লিখি দিবাচোন ৰিচিভ উইদাউট দ্য ইঞ্জুৰি ৰিপৰ্ট তাৰপিছত send back the CD.
13 May.
Item 34.
Lordship, kindly pass over them for today, Lordship. The ex-Honikor has some personal difficulties.
Learned counsel has prayed, learned counsel.
It is related with the 29.
Oh.
26, Lord.
সেইটো কিবা
This Nalbari case, Lord. Nalbari case, LIC agent.
Oh, LIC case. Learned counsel for the petitioner, Mr.
Jay Hatimuria on behalf of Mr. Ex-Honikor.
Joe J. Hatimer has prayed for adjournment on behalf of learned counsel, Mr. A. Khalifa. Is the matter on? Second May.
We need to return the CD or Lordship, retain. 6 May. Retain, we'll retain.
No, 6 May it will be very long. 11 days.
Return the CD, Lord.
Yes.
গম পাইছো কিন্তু এইটো চিডিটো ৰাখিব নোৱাৰো নহয় কোৰ্টেহে জানিব
No,
কি
it
কৰিম।
can have a problem. Send back the CD, call for the up-to-date CD. আহিব নলবাৰী হয় আহি যাব নেকি 6 May.
Item 36.
CD of the-
May I please, Lordship, my lord, 482 petition, my lord. Petitioners are the father and son, my lord. My son is minor, my lord. This is a pre-arrest bail, my lord. So I file this instant petition for.
My lord, here, present petitioner is the owner of the vehicle, my lord. And petition number 2 is the son of the my lord. Owner, that is my lord. And here, what happened, my lord, 600 IMFL bottle was sent for my lord, destination, my lord, for a vehicle, my lord. But in the meantime, they have hijacked the vehicle, my lord, and the materials are yet to be recovered, my lord. And suspect, they are on suspicion, my lord, that son, my lord, although he is minor, my lord, he was present at the time of loading of the my lord, IMFL, as per statement of the witnesses, my lord. Actually, investigation is going on, my lord, and not at this stage, my lord. The bail may not be granted, my lord. As the seized items are yet to be recovered, my lord. And I will also pray for their custody, my lord.
My lord, page number 14, my lord. Annexure 1, my lord, this is FIR, my lord. My lord, petition number 1, Shaban Ali, vehicle owner according to vehicle agreement. And original registered owner is the my lord, Mufidul Islam, my lord. And I am not involved in this case, my lord.
Not, my lord, but from the
My lord,
investigation,
that
it was found that it was in the
that
name of my
600 knots, my lord, loaded by the driver, and he was arrested and released from this bill. And that, my lord, my lord, submitted that was recovered. My lord,
Not recovered, not recovered.
Not recovered, no?
Not
Whatever,
yet recovered, my lord.
Sorry, my lord. That the driver was done, my lord. Driver brought and loaded, unloaded. That in this connection, my lord, petition.
The registered owner. of the
Registered owner is the my lord, is the FIR page 14 is registered vehicle owner is Mofidul Islam. My lord.
Not, my lord. It was, here is the agreement also, my lord.
And
In that
yes, yes,
case, there,
there
my
is
lord.
agreement, and above this, my lord, it is written vehicle owner according to vehicle agreement is Shaban Ali.
And his son was present at the time of the my lord, loading the my lord.
My lord, he is minor. He
600.
does not know what is good,
No,
right or wrong, my lord. He is minor one, my lord. The police is disturbing that he will file this inspection petition for pre-repair. My lord, they are cooperate with this case, my lord. Whatever, when they were called for, my lord. At this stage, my lord, they may be allowed to go on their side.
Okay. I'll pass an order later.
My lord, CD.
I'll go through the CD.
My lord. I flag my lord. Secondly.
Deep level.
May I please, Your Lordship, it came on witness day, Lordship, the 10-wheeler truck, Lordship, which is suspected that some stolen goods were carried by, transported by the truck, Lordship.
You have a CD.
Not a city, 30.
Oh, 30.
City not received, my
No,
lord.
my lord, kindly, Lordship, a 10-wheeler truck, Lordship, is the registered owner, Lordship. Only my offense is that I am the registered owner, Lordship. All persons were arrested, Lordship, driver, handyman, nothing was recovered, only suspected grew up, Lordship, because of the 2 number plates were there in the vehicle, Lordship. And it is a 10-wheeler vehicle, Lordship, driver and handyman looks after the truck, Lordship. So, Lordship, kindly see my situation, Lordship.
Short date.
No, short date also, Lordship, granted with short date.
Please.
But Lordship is not there in next week, Lordship.
Teeny tiny.
Lordship, kindly some local person.
City
No,
not
local today by evening.
No.
Lordship, kindly bear me, Lordship, for it. Today evening itself, I'll go with the document, Lordship.
Today I am not even.
6-5.
Lordship, when Lordship date is given?
6 May.
Much obliged, Your Lord.
My lord, this is first appeal, my lord. LCR is received, my lord, so it may be fixed.
Okay. Appeal.
Appeal, my lord, first appeal, RFA. In fact, my lord, at the stage of my lord, earlier stage, the other side agreed to my lord settle the matter, and it was directed to be listed before the for mediation. But thereafter, my lord, the process could not start. Otherwise, my lord, LCR is received only one.
This was admitted, no? Appeal is admitted already. What about the notices?
Complete
has been
service is
received from
complete, my lord.
civil judge. What about the other side?
Other side appeared, my lord, today.
Yeah, today they are not present.
They are not present.
Okay. Learned Counsel, Mr. M. Gore.
I am JC Gore.
Huh?
JC Gore. My
JC
M. Gore
Gore.
is my daughter, my lord. JC Gore. JC Gore.
Oh, JC Gore is
Well.
present for the appellant. The respondents, the names of the learned counsel for the respondents are shown in the cause list, but are reflected in the cause list, but the respondents are not represented today. LCA has been received. List this matter for already admitted, so hearing.
My lord.
List this matter for hearing.
Well, can it be on next week? Only small, it will hardly, it will take some time. On
Date?
next Tuesday or Thursday, my lord.
Date, you want a date?
My lord.
Date 6 May.
Obliged.
Respondents.
Small permission to make. In this case, I'm yet to receive a copy of the memo paper.
Right now, I'll give.
The respondents are represented. Likhi diya sun. To not represented will
A. Ganguly for the respondent.
London Council, Mr. A. Ganguly is present for the respondents. The petitioner, the appellants are directed to furnish copy of the appeal memo to the respondents within 2 days or
Today itself, I will give.
During the course of the day. I have listed it for hearing. I have given a date also.
Okay.
Item 14.
Obliged.
Item number 14.
Last date, the case was fixed for admission hearing.
Okay.
Actually, this suit is for specific performance of contract. But last date, a point was raised by the Honorable Court whether it will be a revision or appeal.
Okay.
So revision is actually applicable in section 6 of a specific relief act when only possessory right is case for possessory right has been filed. Here it is a case for specific performance of contract. So it will be a appealable order. So my suit has been partly decreed. Only alternative relief has been decreed. Specific performance of contract has not been allowed. So I have preferred this appeal.
It is an order passed or it was a judgment passed?
Judgment decree.
Judgment was passed.
Judgment decree.
And then why was this question raised?
Actually, I still could not find the point because we have stated that after execution of salary recovery position, it means the delivery of position has to be provided. Most probably that for that recovery of word that some may be confusion or etc. But this suit is, and we have specifically the suit is for specific permanent contract.
This was listed for hearing on admission
Last date, not today, it is at order.
for orders.
So my humble request is that it's an appealable, specific order is appealable order, so it may be admitted.
I'll also have to hear it thoroughly.
So I have no objection, Your Lordship.
I'll have to hear it thoroughly because you see, on what ground this matter point was raised, I'm also not aware. I'll have to go through the judgment also. You'll have to show me. Otherwise,
Judgment is okay. Judgment is partly decree. Judgment to এনেকুৱা কোনো কথা নাই মানে matter নাই যে repealable very এটো তো কোনো point নাই. But one is point that whether specific performance contract decree is appealable or revision. So specific performance of contract or case is appealable. But section 6 or G2 recovery of possession আছে only on the basis of possession, not on the basis of title. That আৰু এনেকুৱা Supreme Court or the judgment to dispute.
yes.
Yes. Both the cases are specific performance of contract. এটা ডেলিভারি অফ পজিশনের কথাও কোয়া আছে প্রথমতে লিখা আছে গতিকে সুপ্রিম কোর্ট both the cases has been listed before Supreme Court after trial court and high court order, so it is appellate jurisdiction.
চাই ল'ব লাগিব মই গোটেই ভালকে ধৰিব পৰা নাই কথাখিনি মই চাই লৈ পঢ়ি মেলি চাই
মই লাষ্ট ডেটত মই কনফিউজ হৈ গলো মানে যেতিয়া when court points out that matter
যেতিয়া ৰেজ
মানে স্পেসিফিক পারফরম্যান্স অফ কন্ট্রাক্ট টু তাৰপিছত it is an appellable order. কিন্তু সেকশন 6 ৰ স্পেসিফিক লিখা আছে মোৰ কেছটো সেকশন 6 ৰ নহয় মই যদি প্লেইনটোৰ পেৰাকেইটাও কোৰ্টক দেখাই দিম
প্লেন এটোতো থাকিব ন
না প্লেইনটোত মই
ইনডেক্সত আছে ন মই থুই
সুট ফৰ স্পেসিফিক পারফরম্যান্স কন্ট্রাক্ট ডেটেড সো এন্ড সো আৰু প্ৰেয়াৰতো আছে এটা
গো টু দা প্লেন
প্লেইনটোৰ প্ৰেয়াৰটো মই কোন তথাপিতো মই কৈ দিছো মানে অন্য কাইন্ডলি বি পেজ দা পেজ নাম্বাৰ 45
45 no
A decree for specific performance of contract dated 16/12/2020 directing the defendant number 1 to execute final settlement in favor of the plaintiff in respect to the suit lien by receiving the balance amount. That পিছত এটা মানে আছে point number 3 plaintor. A decree for recovery of possession of the suit lien by which is more fully described in the schedule of the plaintiff in favor of the plaintiff after execution of the sale deed. সাধাৰণতে জেনেৰেলি হয় সেল ডিড এক্সিকিউশন কৰা ডেলিভাৰী আজিকালি এইবিলাক বাৰু প্ৰেয়াৰটো নিদিলেও কথা নাই সুপ্ৰিম কোৰ্টৰ নোটিছ যেতি হয় কিন্তু এটোতো মোৰ সাবসিকুৱেন্ট সেল ডিড হলেহে মোক ৰিকভাৰি পজিশন দিব গতিকে মোৰ এটো সেকশন 6 ৰ কেছ নহয় এটা কোৰ্টে অৰ্ডাৰ সাইকেল পাস কৰিলে হল মোৰ কোনো আপত্তি নাই
ঠিক আছে
যদি appeal admit it is notice may be issued the recovery word to actually delivery position by handover position এনেকুৱা হ'ব লাগিছে কিন্তু plain should be read as a total
এটো নাম্বার 3 আছে না prayer number 3
treat recovery position after execution of sale deed আৰু prayer number 1 2 বিথিন মানে কোৰ্টৰ prayer দিয়া হৈছে যদি মানে প্লেন ডিফেন্ডেন্টে এক্সিকিউট নকৰে তাৰ প্লেনটি মানে কোৰ্টে এক্সিকিউট কৰি দিব লাগে that prayer is available in the case. The suit is basically for specific performance of contract. Now the question is whether specific decree passed in a specific performance is appealable or revision. It cannot be revision. And section 6 or যেটো কথা কৈছে মই section 6 or ইয়াতে provision to ইয়াতে লিখা আছে section 6 or কেছত specific relief factor suit by person disposes of immovable property. মোৰটো dispositionৰ কথাই নাই. There is no question of disposition. ইয়াতে 6 section 6 subsection 3 লিখা আছে no appeal shall lie from any order or decree passed in any suit instituted under this section nor shall any review of any such order or decree be allowed. So it is revision. So it is for recovery position. only on the basis of, not only basis of possession, not on the basis of title. So it
Oh,
has,
yeah, now I got your point.
this case has to be filed within 6 months from the date of disposition. Recovery of possession without basis of, only on the basis of possession, not on the basis of title. It is, limitation period is 6 months. For recovery of possession, it is 12 years of limitation period. So
Appealable or this is appealable order, not revision.
not division order, it is appealable order. And my case is under section 10. Under section 10 of
Yes.
specific relief act, the enforceability of cases in which specific performance of contract enforceable. Specific performance of contract, chapter 2, section 9 or arambo hoise. Defense respecting suit for specific reason and the cases under which. So it's an appealable order.
Okay.
Obligation.
তো এনেকে লিখি দিয়াচোন heard learned counsel. Will come for order only. Heard learned counsel Mr. H.C. Sharma, no?
H.C. Sharma.
For the appellant. Then I'll pass an order. I'll fix a date later. List this for order লিখি দিলে। I'll pass an order.
Obligation.
একটু specific relief এখনো দিবা। By slip করে দিলে।
দি দিও ভাল মতো
না না by slip করে দিলে order kan
না,
date দিবি।
এটা পাঠিয়ে দিই মারি তো
এখন মিলামি date দিবি। Item 32.
May it please your lordship. Lordship, this is a charge-sheeted case. This police charge-sheeted up to the IMA absconding lordship. The trial is going on, lordship. Last occasion call this case a scanning copy of the case.
My lord, I have gone through the record, my lord. Here, the next day restriction 6625 for appearance, my lord. Others accused persons were already appeared, my lord. He is yet to appear, my lord. During the investigation, he has not cooperated with the investigation, my lord. In the charge sheet, my lord, he was shown as absconder, my lord. And offense, regarding the offense, my lord, he has assaulted, my lord. He and other persons, my lord, assaulted two injured victim, my lord, by sharp weapons, my lord. Thereafter, after investigation, police has submitted charge sheet against all the accused persons, my lord. And during the investigation, several attempts were made to arrest him, my lord, but he is absconding, my lord, evading arrest from the.
When was Sasit submitted? Someone says
31-8.
My lord.
Someone was issued, lordship. Someone also
only
received.
summons have been issued.
My lord.
31-8.
But you are apprehending that you will be forwarded to custody.
Yes, lordship. Therefore, my prayer is lordship, given any
Yes.
condition, lordship.
I'm hearing for that.
Inform
Informal
me.
lordship. Earlier 2 times, this honorable court after perusal of CD, bail was rejected, lordship.
That was every lordship, the
Lordship.
medical report.
Everyone
Use-
earlier rejected.
Use materials against him, lordship.
Lordship, as per
So
the medical report, that was says the injury is simple, lordship.
But simple,
Therefore, simple.
it is not the minor matter that simple injury may also cause minor death of person. Minor here, 307 is also there. Minor.
Strangulation also injury
Minor.
turns out to be simple.
Minor.
Strangulation. But strangulation, you know why people strangulate people.
Minor. I have taken my minor.
Lordship, I am ready to face the trial, lordship. I am also ready to
Injury in
common,
the
lordship.
abdomen, one person and another in the head. Scarf.
May I submit? My humble prayer is in respect of the present petitioner, lordship. Please.
No, all of them others are appeared.
All appear.
Only he is evading arrest. And injured person also specifically mentioned his name. He is assaulted.
Where's the FI
FL page 10, lordship.
and charge sheet?
That is page number 16.
Let's see. I'll start dictating and I'll finally decide. I'm not sure. Our learned counsel, Mr.
A Islam.
A. Islam for the petitioner Inus Ali, comma, learned additional PP Mr. B. Sharma
My lord.
for the respondent state and learned counsel Mr.
R Islam.
R. Islam appearing for the informant. Charge sheet has been laid against the petitioner showing him as absconder. The petitioner is willing to cooperate with the trial and he has approached this court for pre-arrest bail. And he has prayed for pre-arrest bail. He approached this court.
That was already rejected by
Prayed for
lordship, my lord.
pre-arrest bail. Full stop. It is submitted by the learned additional PP and the learned counsel for the informant that earlier the petitioner's prayer for pre-arrest bail was rejected.
After perusing case diary.
No, after perusal of the case diary, full stop. The petitioner then disappeared and failed to cooperate with the investigation. Full stop. The petitioner is thus not entitled to pre-arrest bail as this is a case under section 307 IPC. Full stop. I have considered the submissions at the bar with circumspection. The FIR unfolds that on 13/3/2025 at about 3 p.m. while Sanwar Ali was returning home, the petitioner along with the other accused named in the FIR caused grievous injuries on Sanwar Ali by attacking him and stabbing him on his head and other parts of the body with sharp weapons like Khonti, KHA and TI and rods. Full stop. The petitioner and the other his co-accused attempted to commit murder of Sanwar Ali, who was protected by a neighbor named
Sabed Ali, he was also a self-defense.
Full stop. It is further alleged that Sabed Ali was also attacked by the petitioner and his co-accused while he tried to prevent the fight. Full stop. He tried to prevent the attack. Full stop. The scan copies of the case record reveals the pictures of the injuries suffered by the petitioner, which appears to be grave. Full stop. The petitioner has sustained sharp cut injury, which was stitched on his head. The victim has sustained sharp cut injuries on his head, which was stitched. The medical legal report reveals that the injuries are simple in nature, but the injuries were on vital part of his body. Full stop. Charge sheet has been laid against the petitioner and his co-accused. Where is the charge sheet at page?
Page number page 16. Lordship.
Because this, I cannot find the charge sheet in the scan copies because both sides I have to check. Very difficult. Page 16.
Page 16. Cancel it.
My lord, charge sheet number 183 of 24.
No,
Dated 31/8.
Charge sheet number is not required.
31/8.
No, charge sheet number is not required.
Well.
Charge sheet has been laid against the petitioner under section 147/148/342/323/307 IPC. It is true that charge sheet has been laid as there was on the basis of sufficient materials found against the petitioner. All the other co-accused have been arrested and forwarded to custody, whereas the present petitioner was evading arrest. Now the petitioner is willing to cooperate with the trial. Summonses have been issued against him. The petitioner is apprehending that he will be forwarded to custody as Hasid has been laid in connection with a sessions tribal case. Full stop. I have considered the submissions that the petitioner is willing to cooperate with the trial. Thereby, the petitioner is directed to appear before the CGM. Before the learned CGM South Salmara, Mankasar. And the petitioner shall be released on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the learned CGM. Under the conditions that the petitioner shall cooperate with the trial, the petitioner shall not leave the jurisdiction of the court without prior permission till completion of trial, and the petitioner shall refrain from such activities with which is alleged. On breach of any of the bail conditions, the jurisdictional court stroke Eleka magistrate is at liberty to cancel the bail granted to the petitioner.
Item 30.
Much.
May I please?
Yes, yes.
Anticipatory bail application, my lordship. In this case, my lordship, in connection with this case, the 6 accused persons were arrested. And later on, 1 accused person landlords on bail by this honorable court, and others 5 are on subordinate court, my lordship. In this case, she is the professional driver, my lordship. Is not involved in this case. By imposing any condition, they may be allowed to go on bail. He is face the trial, my lordship.
My lord, we have not
Today
received
the
the
date
case
fixed
there,
for
my lord.
second time CD.
CD, we'll need the CD.
My lord, CD not received, my lord.
CD has called for is not received.
My lordship, in the meantime, I will face the trial, my lordship. Already 6 persons were arrested. Later on, they were landlords on bail, my lordship.
Short date, very short.
7.
7.
Obliged.
Standing item 11.
I'm sorry, but I was not there in the morning. My lord, here, it's a regular application.
11 and 14 also.
My lord,
You have for 14.
but 14, same case, my lord.
For 14.
No, item number 12.
14, my lord, same case, my lord.
You are
different-
for 14.
Yes, yes, yes.
Okay.
14 is a anticipatory bail, my lord, and this is a regular bail, my lord. Here, my lord, commercial quantity, my lord, but lordship's earlier order, lordship kindly have a look once, my lord. That lordship find at page 52, my lord.
52.
52, my lord. So there, my lord, lordship may kindly have a look at para 7, my lord. So charges were framed under so and so at this juncture. So therefore, para 8, my lord. So at this juncture, petition with prayer for bail is rejected. However, my lord, lordship directed that to make an endeavor to dispose of the case within 6 months, my lord. So now, my lord, when we moved that earlier application, my lord, that was rejected on 19/12/2023, my lord. The accused before lordship, my lord, he was in incarceration for around 1 year, 2 months, my lord, at that point of time, my lord. Now, my lord, this application we have moved, my lord, after, my lord, 1 year, 4 months of the earlier rejection, my lord. And now, my lord, the accused before lordship, he is in custody, my lord, for 2 years, 6 months and 6 days, my lord. So only on that count, my lord, because there are, lordship knows, my lord, there are several orders, my lord, prolonged incarceration, my lord. Only thing it's
2 years, 6 months, 6 days.
6 days. And my lord, the order sheets, my lord, we have, my lord, also, my lord, annexed in our application, my lord. If your lordship, I'll just, my lord, here, my lord, page 29, my lord. Then the first time the summons were issued, my lord, page 29, my lord. Not just seen, my lord.
How many witnesses have been examined?
No, only one, my lord.
Yeah,
Only
how many enlisted witnesses?
eight witnesses. And only to be fair enough, my lord, last 2 dates, my lord, we are not sure, my lord. Last 2 dates, my lord, that instruction we do not have, my lord, specific. But here 8 witnesses and one witness examined. Around 30 dates given, my lord. Now, all dates, my lord, we have annexed those orders, my lord. Lawsuit found, my lord, from page 29, my lord, till, my lord, page 45, my lord. So here, lawsuit find that, my lord, we have, should I give the dates? Not necessarily.
You can give the dates.
Yes, my lord. Here, page 32 is the first when summons were issued, my lord. Now, my lord, that was dated 13/3/24. It is there in the petition. Again, my lord, on page 33, I'm sorry, my lord, first page 29, I'm sorry, summons issued. Then page 30, that is lawsuit find, PW is absent. Again, next date, my lord, page 31, absent, my lord. Again, my lord, page 32, absent. Then page 33, absent. Page 34, absent. Only page 35, kindly have a look, my lord. One witnesses came, my lord. So we took time, my lord. So that 1 month may be excluded, my lord, because it is for our fault, my lord. They took time, my lord. My lord, I am showing that order, my lord. One witness came, my lord, page 35. He could not be examined because the defense lawyer took time, my lord. And the next date was on 24/6 next month. So around 25 days. But on the next date, it was taken, my lord. That is page 36. Now, my lord, again, my lord, page 38 absent, my lord. Page 40 also absent. Page 49 absent. Page 44, 45. So all these dates, my lord, starting from 21/12/23 till 30/11/24, absent, only in one day came.
Yes, I think CISF or BSF, they do the investigation most of the time.
My lord, my lord.
Witnesses,
And
it's
many
very
cases,
difficult to procure witnesses.
many cases we have also seen voluminous documents, but ultimately during trial, my lord, it gets lengthy and all, my lord. So here, my lord, already 2 years, 6 months, and the delay caused not because of the petitioner's side, my lord, accused side, my lord.
What is the contraband?
Contraband, my lord, commercial ganja, my lord.
How many truckloads?
My lord, one truck, my lord, it is, my lord, Caesar list, we have annexed, page 18, my lord, it is 3,192 kg, my lord. One truck, my lord.
And you are the truck driver or?
I was in the driver, my lord,
You're
the
a
vehicle,
driver?
my lord. Yes, my lord. But he is not the registered owner, my lord. He is not the registered owner as per the document. He was in the truck. That's
Not the
it.
registered one.
Not the registered owner.
You are not the driver also.
My lord, possibly the driver. Yes, driver. My lord. On merit, I am not, my lord, submitting because, my lord, that only on the count of prolonged incarceration, my lord. And lordship knows, my lord, that it mitigates my lord, militates that, my lord, fundamental right, my lord. Now, should I place this or not necessarily? Some order.
Yes, yes. Ravi Prakash.
Ravi Prakash and other, I have given the, in the first page, my lord, one we have given the Dehe to Didya, Potham Kagos. That first is Ravi Prakash, my lord. That list we have given, my lord, in your lordship has got it, my lord, the list, my lord. Then the second case, my lord, it was 1 year, 6 months, my lord. Then the third case, my lord, that was 11 months, 3 days,
Oh, Ravi Prakash will work, I think.
my lord.
Because so many cases. I think
Lordship,
only 4 cases.
lordship
The
may see
rest are
this
set.
case, very.
Huh?
Lordship may see that we have made that, my lord, list of
Yes, yes,
cases.
that I'll keep.
Yes, sir. From there, lordship may, whichever lordship.
But the rest of send it back, I'll save your paper.
Yes, 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 yes. No,
For
we
the
have
sake
got
of
copy,
the
my.
environment, I'll save the paper.
Yes, yes, my lord.
Yes.
And in one, my lord, High Court, my lord, our High Court, my lord, we appeared that number 8, my lord. There, my lord, although it was
Just randomly taken, I'll go through it.
my lord, my lord, my lord. And regarding that anticipated bail, my lord, statement of purpose, that I leave it to your lordship, my lord, because AB, my lord. 14, my lord. And regarding this, my lord,
Same, out of same FIR.
same FIR, my lord. In the forwarding report of the present accused, my lord, it is stated that the person in item 14, my lord, he was the main person. That Lakshmi, Lakshmi, can you take a once, my lord, that item 14, my lord? I'll just. Right.
Yes,
14, my lord, page 21, Lord should see, my lord, kindly have a look once, my lord.
page 21.
21, my lord. The forwarding of the another co-accused person who was arrested in connection.
Okay.
So their last line, Lord should find, my lord. The other co-accused person stated that these articles, my lord, were of that Oppu, my lord, and Oppu is the petitioner in, my lord, that item 14, my lord.
Okay.
So regarding Oppu, I leave it to your lordship discussion. And so far this regular bail, my lord, 2 years, 6 months, 6 days in custody. Lordship may, if possible, consider that.
Yes.
There is that grounds of arrest, but we are not going into that, my lord, because possibly some reservation of this good. So, my lord, we are not on that now, my lord. Only on the length of detention, prolonged incarceration. my lord.
Because during trial, maybe there is some reservation relating to grounds of arrest.
Yes, yes, ma'am.
I think so.
Yeah, maybe
There was deliberation going on in the Supreme Court also.
that possibly would be
And
make it
interception
clear,
also.
my lord.
And interception.
Yes, yes,
Interception, Naka checking.
yes, yes, yes.
Trying to escape. All
Those
these
things
grounds
are
are,
there.
I think it's.
If it is clear, my
sub
lord, then it
judice.
is good for all, my lord,
Yes,
because
yes.
otherwise taking cue of that, my lord, everyone is coming out. That is also a fact, my lord.
Yes.
So if some guidelines or some directions are there that,
Unfortunately, yesterday 103 also.
yes, yes,
I
yes,
had
yes.
to grant bail.
Yes, yes, yes. Because my lord, statutory mandate day after
Yes.
141.
103, I had to grant bail.
Yes, because until and unless, my lord, because it has to be cleared by the Honorable Apex Court, my lord, in some other case. So that case which has been reserved, my lord, if something comes out from that, my lord, it will be good for everyone.
Yes.
Some limitation for us also then.
Yes, yes. Everybody should.
Balance has to
You
be.
should. There should be a balance.
Balance,
everywhere,
exactly,
because
exactly.
prolonged incarceration is also not good.
That also, my lord, if
Absolutely not good.
but if possibly if it is
Without trial.
but if my lord, with all respect, my lord, if it is because of the accused person, my lord, that they were taking dates, and if there may be some reason in some cases, my lord,
Yes, yes.
some reasons in some cases. Otherwise, my lord, because our criminal jurisprudence itself is that, my lord, until and unless somebody is
Without trial, it's not good. It's not. It really curtails your liberty. Prolonged incarceration
yes, yes,
without trial, it's really not.
that is that because we have seen, my lord, voluminous, my lord, records, then several, my lord, witnesses. Or out of, my lord, 30, 40 minutes, only 2 or 3 or 4, 5, my lord, there was a
Come up.
vital.
Year,
And they
year
will
after
come.
year, these people won't come.
Yes.
Witnesses. They
In
won't.
NDPS cases, also, we have found, my lord, 3 years, 4 years, 5 years, lots of also seen.
NDPS happens because in Koimgan side, the BSF, they take up the investigation along with these people, with the police.
My lord.
And then they keep on calling the BSF people and they
They
won't
don't come.
They are getting transferred to Haryana,
Different places.
then Punjab, Jammu and Kashmir, and they won't come.
And sometimes abscondings also there.
Yes, yes.
Some accused
They are
absconded.
absconding, yes.
It takes time to split up and all, my lord. So those difficulties are there, my lord, definitely, man.
My lord, it's a charge-sheeted case, my lord. I have produced the scanned copy of the record, my lord. My lord, 27/10/2003, my lord, charge frame, my lord. My lord, thereafter, my lord, on 24/6/2024, one PW examined, my lord.
27/10/2023,
Charge frame, my lord. And my lord, charge sheet submitted, my lord, probably. He has not annexed, my lord.
Charges ordered at page 28. We have annexed in our petition. Charge sheet letter 9. 9.
And my lord, this my lord, order, my lord, framing charge, my lord, Rosibes also mentioned, my lord, while rejecting the my lord first application, my lord. Order dated, my lord, 19/12/2023, my lord. 19/12/2023, my lord, Rosibes already recorded, my lord, charges frame on 27/10/2023, my lord. After that, my lord, till now, my lord, only one witness examined. I have gone to the order sheet, my lord. The PWs, they are not turning up, my lord.
So I'll then bail that.
My objection may be recorded, my lord, because it's a commercial quantity, my lord.
Huge
Because-
commercial quantity, 3,000
Huge,
kilos.
huge, my lord, huge. And it is
3,000
recovered,
kilos will be 3 quintals, I think.
it is recovered from the possession of the, my lord, he was a truck driver, my lord.
Huge commercial quantity.
Some courts, my lord, 1 year, 5 months, it is 6 months, it is granted. Some courts, 1 year, 3 months, like the different
No, I have found, my
parameters.
lord, I
Because
have
it is a
found, my lord,
lordship's take, my lord. We cannot insist also.
my
my
lord,
lord,
11
because-
months also, my lord, bail granted, my lord.
my lord,
11 months.
11, it is not possible in NDPS case, my lord, to, my lord, start a trial, my lord, within 11 months, my lord.
And possibly we have to see, my lord, whether
Actually,
delay.
should start.
Because, my lord, 360
Why-
days,
Comments actually.
360
because
days is the investigation period, my lord.
309 is also
We
there. my
don't
lord.
have the courts, we don't have the infrastructure, that is the problem.
But 360
Others,
days,
should commence.
360 days is the investigation period, my lord.
Yes.
Then, my lord, how
If
can it be
extended.
completed in, my lord, within 11 months?
If extended, then only.
If extended, my lord, but statutory had given the power, that liberty, my lord, that 360 days is a, my lord, period. In which, my lord, investigation has to be completed.
You know, and only FSL reports are, it takes time, my lord. Otherwise, when there is a case of, my lord, clear-cut case of, my lord, direct possession, somebody's recoveries are made. So delay should not be there while filing charge sheet also.
Actually, drawing sample from a truckload of 3,000 kgs also is very difficult.
Take time.
From each basta, they have to take out the
Different samples, yes, yes.
54 grams, I think.
Yes, sir.
When it comes to ganja, 189,
Right.
that schedule, it has to be 24 grams.
And, my lord, secondly, my lord, this petitioner, my lord, he is from Tripura, my lord. So there may be some strict conditions.
Yes, local and everything.
They are always from Tripura and some neighboring states only. They are
Tripura,
not
lots of
Manipur,
cases.
Tripura.
Manipur,
Nowadays, Tripura, this is, both cases.
Third learned counsel Mr. A. Chaudhary for the petitioner Manik Singh, who has filed this petition under section 4, equal 3 of the BNWS 2023 with prayer for bail as is behind bars since 19/10/2022 in connection with sessions in connection with
Special NDPS.
special NDPS case number 153 of 2022 arising out of Bazari Sera PS case number 187 of 2022 under so and so sections. Heard Mr. R.J. Borua, learned additional PP Assam. It is submitted on behalf of the petitioner that earlier his bail petition was rejected on 19/12/2023 by this court. Full stop. A direction was also given to the trial court to make endeavor to dispose of the case without procrastination. Full stop. Full stop. Now, after 1 year, 4 months, the petitioner has prayed for bail. Full stop. He has been languishing in the jail for 2 years, 6 months, and 6 days, and so far only one witness has been examined. Full stop. It is submitted. It is also submitted next. It is also submitted on behalf of the petitioner that 8 witnesses are enlisted, and thus, as in a span of 2 years, 6 months, only one witness has been examined, and as Lihlano, and as in a span of culmination of trial appears to be remote. Full stop. The petitioner has relied on the decision of the Honorable Supreme Court in Ravi Prakash versus State of Orissa, reported in 2023 SCC Online SC 1109, wherein it has been observed that para 4, the petitioner has also relied on the decision of the Honorable Supreme Court in Zakirul Islam versus State of Assam, wherein by order dated 15/7/2024 in SLP criminal number 3632, the appellant Zakirul Islam was enlarged on bail after incarceration of 1 year, 6 months.
Vale.
The learned additional PP has raised serious objections stating that the petitioner was in a truck which was transporting 3,000, how many kgs?
3,192, my lord.
3,192 kgs of ganja.
Vale.
Full stop. The offenses of a grave nature, the petitioner is not a local resident.
And
and
records of
he-
37 will come, well.
Huh?
Records of 37
Yes,
will come.
yes. The petitioner is not a local resident and he is thus a flight risk. To stop the rigors of section 37 of the NDPS Act fetters the bail petition, full stop. I have considered the submissions at the bar with circumspection, and I have also scrutinized the trial court records and the case diary, full stop. It is true that the petitioner was intercepted while he was transporting 3,192 kgs of ganja, full stop. The petitioner has denied his involvement in transportation of the contraband, full stop. It is also true that the petitioner is facing trial and charges have been laid against him. Charges have been framed against him. Full stop. I have considered the length of detention and it appears that trial has been procrastinated by the state and by the court. I have also relied on the decision of the Honorable Supreme Court in Robi Prakash Supra and Zakirul Islam Supra. To stop, there are 8 witnesses and in a span of 2 years, 6 months, only 1 witness has been examined. In the wake of the foregoing discussions, it is held that bail may be granted to the petitioner. I have considered the submissions that the petitioner is willing to abide by any stringent bail conditions if imposed upon him. Full stop. Considering all aspects, the petitioner is enlarged on bail of rupees 1 lakh with 2 local sureties of like amount to the satisfaction of the learned trial court under the condition that the petitioner shall not jump the bail and cooperate with the trial. Full stop. The petitioner shall refrain from such activities with which is alleged, and the petitioner shall not exercise threats to witnesses or try to influence them. On breach of any of the bail conditions, the court is at liberty to cancel the bail granted to the petitioner.
He religiously appear before the trial court without fail, my lord.
Huh?
Another
Content, I have not given it
It is-
because it's from
because-
Tripura.
Okay, my lord, I'll leave it.
Not jump the bail.
My lord, my lord. And another aspect, my lord, because my lord, 2 dates we are not aware, my lord. My lord,
No, he is submitted.
so
only
my lord,
one
that
witness.
I'm making it clear, my lord.
Oh.
2
No,
dates,
no, it's
last
okay.
2 days we are not aware.
It's okay.
My lord,
Because there was a submission of this kind in this court.
My lord.
Then both the sides have agreed
My lord.
that the statement of the victim has been recorded, not you,
My
some
lord.
other
My lord.
advocate, not you also. So both statement, I have noted it down and then that district judge he
Yes,
sent
yes.
me a letter
Yes, yes.
that this has been,
Yes, yes, yes.
this court has been misled by this type of
We should
submission.
be fair
Statement
always.
of the victim was not
My lord,
recorded.
cases will come and go. We are not, my lord, because we should be fair, my
Because
lord.
send me a letter.
Yes, yes, because that's why, my lord, other 2 dates, if witnesses came, I don't know, that's why.
Yes, no, it's okay. He's also submitted that only 1 witness has.
My lord, my lord. Much obliged, highly obliged.
It will reject with her.
14.
It will reject with
My
her. It will AB. হেৰি এইটো behind bars hours এইবোৰ লিখিব নালাগে ৰিজেক্ট কৰিলে হৈ যাব ষ্টৰিটো অকমান লিখি দিবা ই ৱাজ ট্ৰান্সপৰ্টিং 3,100 বনাই মেলি এইটো ৰিজেক্ট কৰিলে হৈ যাব AB is rejected. Rejected.
It is the lordship.
Hmm.
Lordship, in this case, I'm in custody for last, my lord, 2 years, 1 month, 2 days, as on today, my lord. Which, my lord, stands at 764 days. And till date, my lord, trial court has not framed charges. Now, my lord, in this case, I have also taken the grounds of arrest, my lord, which is by my additional affidavit. I have brought this before the honorable court, which is there in under flag F. And if Lordship peruses page 72 of the affidavit, that Lordship will find that only a notice has been issued informing that I have been arrested. Now, the same I'm arguing, my lord, this point because I was not named in the FIR, not even, my lord, implicated by the apprehended accused also. There is Lordship will find in the FIR the apprehended person, not even, my lord, implicated in the present petition. It is only based on confessional statement of another person who was
Grounds of arrest, additional affidavit page.
page 72, my lord. Lordship will find the section 50 notices there. And memo is also I have annexed, my lord, which is at page 71. That also speaks of nothing, my lord. In fact, there is no such column even. And if Lordship, and in the trial court record, my lord, I have flag marked the same. Lordship has dealt with this issue, my lord.
Okay, this you may be granted bail, but these grounds of arrest have been communicated to you under section 50.
My lord, it is Lordship knows that in public book. This morning, Lordship has dealt with this issue, my lord.
This it has been even according to public Pukasta also it has been communicated to you.
But-
Such in and you have given your signature in English. It has been communicated only because of the length of detention. Maybe your bail can be considered.
It is
Not grounds of
I
arrest.
leave up to your Lordship, my lord. Otherwise, my lord, also I'll be highly obliged, my lord. 2 years, 1 month also, my lord.
After case, my lord, I have don't be responsible, my lord. I just submitted on my lord 31/5/2023.
Sasi?
Submitted. 31/5/2023.
2 years, my lord.
Citing 15 numbers of witnesses, 18 numbers of witnesses in the subject, my lord. But till now, my lord, charges will not be framed, my lord. Because, my lord, due to non-appearance of the accused, some of the accused. And the as per the report, my lord, in a trial court, my lord, next day it speaks on 3/4/2025 for consideration of that.
I'm granting bail.
But otherwise, my lord, it's a commercial quantity, my lord.
But
What is the quantity?
my lord. Java tablet recovered from one Hadimit Chaman, my lord.
Yeah, but tablets.
$86 kgs, my lord.
86 kgs.
Yes, my lord. My lord, but
You
Lordship.
want to kill the entire
No.
district.
My lord, if had it been, Lordship, had it been,
Entire district will die.
exactly, my lord, but Lordship, I would have made submission if it had been recovered from this possession. If Lordship will find in the FIR, my lord, it is not even named. But I don't know, my lord, it is the investigating officer, they have later on arrested me, saying that one Salimuddin has implicated me. He has also been granted bail. That is also on record, my lord.
Okay, okay. Our learned counsel, Mr.
M.A. Chaudhary.
M.A. Chaudhary for the petitioner, Abdul Qadir Loskor, who has filed his application under section 483 of the BNWS 2023 with prayer for bail as is behind bars since 28/7/2023 in connection with special NDPS case number 8 of 2023. Third learned additional PP, Mr. R.J. Borua, for the respondent state. It is submitted on behalf of the petitioner that the grounds of arrest were not communicated to him. The annexure B is a notice under section 50 of the CRPC, which clearly reveals that the grounds of arrest were not communicated to him. The annexure A is the arrest memo, which also clearly reveals that the grounds of arrest were not communicated to him. The petitioner has relied on the decision of the Honorable Supreme Court in Bihan Kumar versus
My lord, Bihan Kumar versus State of Haryana.
State of Haryana
Reported in 2025 SCC online SC 269.
and also on the decision of the Honorable Supreme Court in Probi Procastor versus
State within bracket NCT of Delhi reported in 2024 8 SCC 254.
what are the paragraphs you're relying on?
My lord, paragraph mainly I'm relying on paragraph 19 of Probi Procastor, my lord.
Procastor paragraph 19.
19, then my lord, I'm relying on paragraph 45, my lord, and 48 also, my lord. These paragraphs.
Only one paragraph.
Then my lord, 19 and 45, my lord.
19 and 45. Aru Bihan Kumar paragraph.
Bihan Kumar paragraph, my lord, I'm relying. Yes. My lord, I'm relying on paragraph 16 because there, my lord, it is held. Paragraph 16. Yes.
Please give me the judgments.
Yes, my lord. I have prepared the compilation, my lord.
No, the judgments. Only these two judgments I want. No, he'll find it very difficult. Only these two judgments.
Provided Bihan is there, my lord. Serially, I have. First, last
এখন check করে দিও নাকি? Provi and Bihan, no?
Yes, my lord.
Only these two judgments.
Yeah, others are there, but
He won't understand.
others I have also annexed, my lord. That Ashish.
কেছিখন কাটি পেলাই কবি আৰু জ্ঞান উলিয়াই দিব দিয়ে কেছিখন দি কাটি পেলাই তেখেতক দি দিয়ে he won't understand word thing he won't understand he's very new he's picking up fast but he won't understand all this.
Some lordship will be required.
I have also I have also realized that it is further next prayer it is submitted by the learned counsel for the petitioner that trial has commenced. Or the trial has commenced now. No, like it is also submitted by the learned counsel for the petitioner that charges were framed. The charge sheet was submitted. Charge sheet was submitted on 31. Huh? Charge sheet was submitted. Charge sheet was submitted on 31/5/2023, but charges were not framed due to absence of co-accused. The petitioner's right to liberty has been curtailed due to the procrastination of the trial. The learned additional plea has raised serious objections stating that although 18 witnesses are enlisted in the charge sheet, the petitioner's incarceration is not to such an extent that his right to liberty has been curtailed. The rigors of section 37 of the NDPS Act acts as an embargo. Full stop. The petitioner was involved in carrying 86 kgs of Yaba tablets. And this is the reason why charge sheet has been submitted against the petitioner. Full stop. The petitioner is not entitled to bail. Considering the heinous nature of the offense, I have considered the submissions at the bar in circumspection. I have considered the submission that the grounds where arrests were not communicated to the petitioner. I have relied on the decision of the Honorable Supreme Court in Probi Procastor's case supra, and in the case of Bhyan Kumar's, and in Bhyan Kumar's case supra, it appears that bail has to be granted to the petitioner. Both the petitioners are enlarged on bail of rupees 50,000. It appears that bail has been granted to the petitioner. Full stop here. Moreover, both the petitioners to particularly here. Moreover, the petitioners have been behind bars for 2 years, 1 month, and charges have not yet been framed. Full stop. Although
The last update is not available, madam, because the case was fixed on before, madam.
My
The
lord.
update is not available in the.
I have checked, my lord, in the kiosk also.
Although it is submitted there, Last sentence is pahas. And charges have not yet been framed. Now, well, in view of my foregoing discussions, the petitioner, one petitioner, is enlarged on bail of rupees 1 lakh with two suitable surety to his local person, no? Suitable sureties of like amount to the satisfaction of the learned trial court, under the condition that the petitioner shall refrain from such activities with which he is alleged. Number two, the petitioner shall not leave the jurisdiction of the court without prior permission till completion of trial. On breach of any of the bail conditions, the trial court is at liberty to immediately cancel the bail granted to the petitioner. Post of the trial court may also impose further conditions to secure the attendance of the petitioner. Yes. এই জাজমেন্ট কেইটা দিব লাগিব